Hi and welcome. What happens when thousands of clients receive similar legal communications, but a firm cannot easily prove exactly what was sent? In less than a year, the Solicitors Regulation Authority published two significant reports on the high-volume consumer claims market. The first examined what was happening inside law firms. The second asked consumers what the process felt like from their side. Together, they raise an important question. Are firms able not only to provide the right information but also to demonstrate exactly what communication was issued to each client? The Solicitors Regulation Authority, or SRA, regulates solicitors and law firms in England and Wales. On 22 August 2025, it published the results of a thematic review into firms handling large numbers of consumer claims. These may include claims involving financial products, housing conditions, data breaches, or other situations where many consumers pursue similar cases. The SRA surveyed 129 law firms that were collectively handling more than 2.4 million live claims. It then visited 25 of those firms and reviewed 50 client files in greater detail. The review found examples of good practice, but it also identified serious concerns. Only 11 of the 25 firms visited could evidence that all claimants had received the required client care information when their cases were opened. Only 12 had records demonstrating that all required information about costs and claim funding had been provided. The SRA also raised concerns about funding arrangements, referral relationships, after-the-event insurance, and whether firms were acting in their clients' best interests. In ordinary language, some files did not show a complete and reliable record of the information clients should have been given before agreeing to proceed. Then, on July 2, 2026, the SRA published a second piece of research. This time, the focus shifted from law firms' internal processes to consumers' direct experiences. The independent research, conducted by YouGov, included a survey of more than 15,000 adults in England and Wales, together with detailed interviews involving people who had made claims. The results presented a mixed picture. 59% of those whose claims had been resolved said they were satisfied with the outcome. However, 54% reported experiencing problems during the process. The most common issues included delays, poor communication, and a lack of clarity. Many consumers were unsure when they had formally agreed to begin a claim. Only 21% of those using a law firm or claims management company said they had received information about costs at the beginning of the process. In human terms, some people reached an acceptable outcome but still found the journey confusing. They did not always understand what they had agreed to, what it might cost, or what would happen next. The two reports examined different evidence. The first looked at firms, files, and internal processes. The second listened to consumers. They do not prove that one particular technology or process failure caused every problem identified. The SRA found wider concerns involving professional judgment, funding arrangements, supervision, and firms' responsibilities to act in their clients' best interests. Technology cannot replace those responsibilities, but the reports do highlight an operational risk around client communication. A firm may create an accurate client care letter. Compliance may review it. A senior person may approve it. But what happens after that? A revised document may be added to a shared folder while an older copy remains available. A staff member may attach the wrong version to an email. A template may be changed without a clear approval record. The case management system may show that a letter was sent, but not clearly connect that letter to the approved wording used at that moment. Months later, when a client complains or the regulator asks questions, the firm may need to reconstruct the story across folders, email threads, case notes, and different systems. The problem is no longer simply, did we create the correct information? It becomes, can we demonstrate exactly what communication was issued to this particular client? That is where communication governance can help. CommsPliant is being developed as a controlled layer for customer and client communications. It does not replace a law firm's case management system, legal judgment, compliance team, or professional supervision. Instead, it is designed to connect with existing systems through an API, allowing firms to keep their current case management processes while adding stronger control over client communications. Approved templates can be version controlled. Editing and approval responsibilities can be separated. Changes can be recorded. Emails, letters, and PDFs can be generated from the approved version. The system is designed to keep each resulting communication connected to the template, attachments, and approval evidence behind it. This could help a firm answer practical questions more quickly. Which wording was approved at the time? Who approved it? Which version generated the communication? What was issued to the client? What evidence can the firm retrieve later? In high-volume services, small weaknesses can be repeated across large numbers of clients. Clear wording matters. Professional judgment matters. But firms also need reliable control over how approved communications move from creation to delivery. Because storing a document tells you where the file is. Communication governance helps you prove what happened.